opportunity, I say thank you, and I'm greatly indebted to you. To my legal team led by Senior Counsel, Honorable Paul Moite, I want to sincerely thank you for your great representation. Your strategy, professionalism, and dedication made all the difference. I also thank the several independent counsels who litigated various petitions on this on behalf of Kenyans. I'm incredibly grateful to have had you on my side and the side of Kenyans. To the millions of Kenyans who believed in me, stood with me every step of the way, I cannot thank you enough. My heart is full. Your love has been overwhelming. To my core principals, Honorable Stephen Kalonzo Musyoka and Eugene Wamalwa, before, during, and after the impeachment, you have been with me every step of the way. To my core principals of the United Alternative Government, you have been a family to me. To the senators and MPs from across board who stood with me, you are harassed, intimidated, but refused to succumb to bribery. May God bless you. The journey has just begun. To the innocent civil servants, including gardeners, cleaners, tea girls, office messengers, who suffered the brunt of this regime, you are harassed, intimidated, threatened, and embarrassed. Justice will be served one day. This ruling was about you. I know it still pains you, but I thank you very much for standing with me and my family all along. May God bless you and your families most sincerely. We stand here today with tremendous respect to the judiciary of our country. While we respect the ruling of the High Court, we totally and fundamentally disagree on the interpretation of the law and application of facts. The long-standing legal principle of natural justice and the right to a fair hearing has been trashed and ignored in broad daylight. What a sad day for those whom have undergone this in the past and those who face the same in future. We shall proceed to file an appeal at the Court of Appeal on the decision and hope that justice shall prevail. The framers of the Constitution provided for an appellate and Supreme Court. We believe we shall fight to get justice one day. Dear great people of Kenya, just like the millions of you, I'm shocked by the 350-page decision of the three-judge bench of the High Court of Kenya, pronouncing itself and holding that my right to fair hearing under Article 50 of the Constitution was violated, and then ironically purporting to uphold the impeachment. It is lost on all of us how the actions and decisions of Parliament, categorically determined by the three-judge bench as unconstitutional and a product of an unfair process, can then be deemed valid by the same bench. Those contradictions are an abuse to the intelligence of the people of Kenya who are following the process and the judgment many hours on. The fundamental right to fair hearing, guaranteed under Article 50 of the Constitution, determined to have been violated, is amongst a set of constitutional provisions protective of every Kenyan facing any accusation. Article 25 of our Constitution provides rights that are non-derogable. They cannot be limited under any circumstances. At the core is a provision to fair trial. The right to fair hearing bound by Article 50 and in regard to the process. Article 47 demands fair process, requiring mandatory fair hearing. We strongly observe that the impeachment process was found faulty by the three-judge bench for failure to respect my right to fair hearing in the violation of Article 25, 47, and 50 of the Constitution. Once that determination was made, the entire process collapsed and was null and void. There was no impeachment. There was a constitutional coup, an abuse to the people of independent Kenya. The three-judge bench was obligated by operation of the law on determination or violation of the Constitution to set aside the impeachment. The decision by the bench to then purport to uphold the impeachment in the face of its decision or violation of the Constitution is in itself a violation and derogation of its responsibility under Article 165. Decisions made in violation of the Constitutions are null and void. Lord Denning in McFoy declared that if an act is void, then it is, in law, a nullity. It is not only bad, but incurably bad. You cannot put something on nothing and expect it to stay there, it will collapse. How then would a three-judge bench argued that the non-derogable right to fair trial was violation in the impeachment process? Then they turned around and tell the Kenyan people that regardless, the impeachment was valid. What a paradox. Dear Kenyans, we recall that on 31st October 2024, while setting aside conservatory orders issued by the High Court, this very bench gave an undertaking in open court that there did not exist any violation without remedy or outside the reach of the court. They further argued that in the event and as a consequence of setting aside the protective conservatory orders, they determined that if the impeachment process was unconstitutional, they would reverse any actions and decisions taken pursuant to the impeachment. The Attorney General gave the same undertaking through counsel Professor Gedhu Muigai Emeritus. 2 weeks ago, the Honorable Justice Ogola, the presiding judge, categorically stated that the petitioners could not restrain it on the remedies on finding of the unconstitutionality of the impeachment, including the possible reinstatement as a deputy president. Further, on seeking of conservatory orders initially, the High Court insisted that petitioners should allow the parliamentary process to complete, since any decision would be amenable to judicial review. It is then astonishing that in this judgment, after pronouncing itself and determining that the impeachment process violated my right to fair hearing, the three-judge bench purported to hold that the impeachment was nevertheless valid and permanent. In yet another paradoxical determination, the bench decided that the Senate failed to follow expected constitutional impeachment process by refusing to use the required select committee. The Senate instead moved directly to plenary. Then, for no determined reason, in a single sentence, claimed to be bound by the Supreme Court decision in Sonko case, which was in regard to impeachment of a governor, and which decision the bench went on to distinguish. This was exceptionally incomprehensible. Dear Kenyans, in this regard, earlier today, I held a consultative engagement with my legal team led by Senior Counsel Paul Kibuge Muite, and we have clearly analyzed the judgment and have instructed them to challenge this judgment at the Court of Appeal. For avoidance of doubt, I moved to the High Court to fight for my rights and those of Kenyans who participated in the 2022 general elections that have been violated. My prayer was to seek the quashing of an illegal process of impeachment. It is only after the determination of illegality, as has already happened, and setting aside of the impeachment, as should have happened, we were to consider asking for damages for constitutional violations. The 50 million Kenya shillings awarded to me is an insult to my fundamental rights and freedoms and a mockery of the Constitution. We are not interested. Money was never the issue here. Justice and constitutional supremacy was. I am one Kenyan leader who will not and cannot be swayed by promises of money to allow violation of the Constitution. I stand as a matter of principle to protect constitutional rights and defend the Constitution. This is an oath that I sow, and Kenyans know me for that. If I was interested in money, Mr. William Ruto had offered me 2 billion Kenya shillings in an effort to entice me avoid impeachment and choose resignation. But I stood for my rights and that of over 7 million Kenyans who voted for me. I rejected this offer and faced the National Assembly. This is in public domain. No offer, no amount of money can stand between me, my rights, and the rights of the citizens of Kenya